On February 10, 2026, an Abuja High Court issued a clear, binding order, maintain the status quo on a disputed Maitama property. 14 days later, on February 24, officials arrived at that same property with over 50 armed policemen and demolished it anyway. The man who gave that order is not a street thug. He is a trained lawyer, a member of the body of benchers, Nigeria's Minister of the Federal Capital Territory, and now a Nigerian court is moving to have him committed to prison. While every political commentator is debating Wike's legacy as a strong man, nobody is asking the question that actually matters. What happens to the rule of law in Nigeria when the man who controls the capital city treats a court order like a suggestion? Stay with me, because by the end of this video, your answer will have changed. Before we go further, if you are new here, Naija Update 24/7 exists for one reason: to give every Nigerian, wherever you are, whatever region you're from, the political analysis that mainstream media won't touch. Hit subscribe and stay with me. This gets deeper. To understand what is happening, you need to understand how this started, and the timeline matters. In December 2025, a company called Micas Grid Ventures Limited, owned by Alhaji Abubakar Ibrahim, filed a lawsuit in an Abuja court. The case number is M/16354/2025. What Ibrahim was asking the court for was straightforward: stop the FCT minister and a company called Italia Company Ltd from forcefully taking possession of his land at plot 4583, Maitama, Abuja, a parcel measuring just over 8,500 square meters. Justice Hamza Muazu of the FCT High Court heard the application and on February 10, 2026, granted an interim order directing all parties to maintain the status quo. That is standard judicial language, meaning nobody touches anything until this matter is heard properly. The next court date was set for April 23, 2026. That order was served on all parties, including the minister. Then, on the morning of February 24, just 14 days after that court order, officials from the FCT Development Control Department arrived at plot 4583, allegedly acting on the minister's directive, and demolished the fence and security house on the property. Alhaji Ibrahim says he received a phone call from a security operative telling him to vacate before they arrived. He says his belongings, including trucks on the property, were removed without any inventory being taken. Now, this land has a history that goes back 2 decades. Ibrahim originally received the plot allocation in 2006 during Nasir El-Rufai's tenure as FCT minister. At that time, it measured 1.5 hectares, a substantial piece of land. It was later redesigned and reduced to accommodate parking space for the As-Salam Mosque. Ibrahim held that allocation for nearly 20 years. Then, in November 2025, he alleges the land was quietly reallocated without his knowledge, without his consent, to an Italian company called Italia Company Ltd. That reallocation is what triggered the lawsuit. That lawsuit is what produced the court order, and that court order is what was allegedly ignored. I want you to hold one question in your mind as we go deeper into this story. Why would a man with legal training, a body of benchers member, deliberately defy a court order that was already served him? We will come back to that. The answer is more strategic than it first appears. To grasp the full weight of what is happening here, you need to understand the institutions that are now in direct tension with each other, because this is no longer just a land dispute. The first institution is the FCT High Court, presided over by Justice Hamza Muazu. Following the February 24 demolition, the court granted the claimant lawyers permission to serve Forms 48 and 49 on Minister Wike. Form 48 is formally titled the Notice of Consequences of Disobedience to Order of Court. It is not a warning letter. It is the legal document that tells a person in plain, unmistakable language, you are in contempt of this court, and if you do not comply, you face imprisonment. Form 49 is the motion to actually commit, to physically arrest and incarcerate the person in defiance. The court also permitted this service to be done through newspaper publication, which is legally significant. It means Wike cannot argue later that he was not properly notified. That door has been closed by the court itself. The second institution is the FCT Administration and the FCDA Development Control Department, the administrative machinery that physically executed the demolition. This department operates under the minister's authority. So when those officials arrived with 50 armed policemen on February 24, they came as an extension of ministerial power. The chain of command here matters enormously. The third institution, and this one deserves careful attention, is the body of benchers. This is Nigeria's premier legal regulatory body, the institution that upholds professional standards in the legal profession. Wike is not just a politician. He qualified as a lawyer. He is a member of this body. His alleged defiance of a court order is therefore not merely a political act, it is a professional one. The Legal Practitioners Disciplinary Committee exists precisely for situations like this, and nothing prevents a formal complaint from being filed there. The fourth institution is the presidency. Ibrahim's lawyers have formally called on President Bola Tinubu to caution his minister. The president has not publicly responded. In politics, silence is itself a position. Now, here is something that has received almost no attention in the media coverage of this story. The plot in question is partly described as a parking space for the As-Salam Mosque. So this is not simply a commercial land dispute between a businessman and a ministry. There are dimensions to this, religious, communal, and institutional, that mainstream coverage has completely overlooked. Remember that as the story develops.
Now, if what I just told you surprises you, drop a comment below. I want to know what you think before we get to the part that changes everything. Here is where the analysis has to be honest and precise, because the political architecture of this case is what makes it truly dangerous. Nyesom Wike has spent his entire political career constructing an image of a man who cannot be stopped. From Rivers State, where he governed for 8 years, survived impeachment threats, survived political betrayals, and delivered results that his supporters still talk about, to Abuja, where he arrived as FCT Minister and immediately made demolitions his signature. Properties came down, streets were redesigned. There was a period where residents of the capital genuinely believed they were watching the city being rebuilt with discipline. That image of invincibility, of a man who acts and does not ask permission, is the political asset Wike has been protecting his entire career. Defying the court order, in that political logic, was consistent with the brand. But that calculation has now produced a liability he may not have anticipated. Because the optics of this situation are no longer those of a strong man cleaning up a corrupt capital. The optics are of a minister who deployed 50 armed officers to a civil property dispute in defiance of a court order he had already been served to seize land that had been allocated to a foreign company without the original owner's consent. Those are not the optics of reform. Ask yourself this honestly. A fence demolition does not require a military-style operation. That level of force tells you this was not a routine administrative exercise. Someone wanted this to be irreversible and wanted it done quickly. Now, consider the Tinubu calculation, because this is where federal politics enters the picture directly. Nyesom Wike made one of the most consequential political decisions of the 2023 election cycle when he broke from PDP and backed Bola Tinubu's presidential bid. In the South-South, his defection created political cover for Tinubu in a region that was otherwise hostile territory. His appointment as FCT minister was the political reward for that alignment. The relationship between the two men is therefore not a normal minister-president relationship. It carries the weight of a political debt. If Tinubu disciplines Wike, either publicly or by withdrawing political cover, he risks signaling to South-South political actors that loyalty to his administration comes with conditions they did not anticipate. If he does not discipline Wike, he signals to every Nigerian watching that ministerial impunity inside his cabinet is acceptable as long as the political loyalty is solid. Neither outcome is clean, and there is a third party in this case that almost no one is discussing: Italia Company Limited, the foreign entity to whom the land was allegedly reallocated. We will come to that shortly because that angle opens a much larger question. For the opposition PDP, this case is a political gift. Here is their former governor, the man they once counted on as their stronghold in the South-South, now facing contempt proceedings from a Nigerian court while serving in a rival administration. The narrative writes itself. But the opposition's enjoyment of this moment does not resolve the underlying institutional problem. This case is not actually about Wike's political allegiances. It is about what the rule of law means when the person defying it controls the security apparatus of the nation's capital. Step back from the personalities and consider what this case means for Nigeria as a whole, for the North, the South, the East, and the West, equally. The FCT is not a state. It is administered directly by the federal government through a minister who is appointed, not elected. That structure already removes a layer of democratic accountability that every other Nigerian enjoys through their elected governors and state assemblies. There is no FCT governorship election that serves as a referendum on the minister's conduct. There is no FCT House of Assembly with oversight authority. The only institution with the structural power to check the FCT minister's actions is the judiciary, and that is precisely the institution whose authority is now being tested. For the average Nigerian, not the Abuja property investor, but the civil servant in Kano, the market trader in Onitsha, the farmer in Benue, the message this case sends is deeply personal. It says a valid land allocation, 2 decades of documented ownership, a subsisting court order, and all of that together is still not enough protection if the person who wants your land has 50 armed officers and a ministerial mandate. That is a message about the value of formal property rights in Nigeria, and it does not respect regional or ethnic boundaries. It applies to everyone. The economic dimension is not abstract either. Foreign direct investment into Nigeria dropped 12% in 2025, according to CBN data, partly driven by concerns about erratic enforcement and unpredictable treatment of property titles. A 2025 Business Day investigation found over 200 greenbelt conversions in Abuja since 2023 alone, many in flood-prone areas. This demolition case does not exist in isolation. It sits inside a pattern of land administration that is reshaping the capital city in ways that will outlast any minister's tenure. And that pattern is what investors, both domestic and foreign, are watching when they decide whether Nigeria is a safe place to commit capital. Once again, kindly remember to subscribe to my channel. I understand it means nothing to you, but it means everything to me. This work of research and analysis cost me a lot, and the only means of paying me is your subscription. Thank you. Public confidence in institutions is not a philosophical luxury. It is the infrastructure underneath economic activity, investment decisions, and social stability. When people believe a court order can protect them, they invest. When they believe it cannot, they pull back. The consequences of that withdrawal are not felt in Maitama. They are felt in the price of food, the availability of jobs, and the pace of development in every corner of this country.
The second defendant in this case, Italia Company Ltd., has received almost no media attention, and that absence is telling. A federal land in Nigeria's capital city was reallocated without the original owner's consent to a foreign corporate entity. That is not simply a domestic administrative matter. It touches on how Nigeria manages sovereign land assets in relation to foreign commercial interests. It raises the question of whether diplomatic relationships are being leveraged in commercial land transactions. The identity of Italia Company Ltd., who its directors are, what its relationship with the FCT administration is, how the reallocation was processed, are questions that deserve serious investigative reporting. For Nigerians in the diaspora, in the UK, the US, Canada, Europe, this case is directly relevant to their financial decisions. The Abuja property market is one of the primary investment destinations for diaspora savings. When a court order protecting a legitimate title holder is ignored by a federal minister, the implicit message to every diaspora Nigerian with an Abuja land title is that their investment security depends not on the law, but on their political connections. Now, The strongest counter-arguments deserve honest engagement. Some will say Wike is simply cleaning up a capital city full of irregularities, and there is truth in that. Genuine irregularities from previous administrations do need to be addressed, but the mechanism for that correction is a formal administrative and judicial process, not a pre-dawn demolition in defiance of a sitting court order. Others will say this is a civil matter that will be resolved in court, and again, that is accurate as far as it goes. But the court process is exactly what was allegedly interrupted. You cannot cite the courts as the resolution mechanism while simultaneously disobeying their orders. And some will argue Wike's political enemies are weaponizing the judiciary against him. That argument is worth taking seriously. He does have documented opponents. But the existence of political enemies does not make a court order optional. The principle that no person is above the law cannot be conditional on the motivations of the litigant. The national interest conclusion is this: for every Nigerian, regardless of region, tribe, or religion, your property, your legal protection, and your court order are only as strong as the weakest point in the system that enforces them. If that weakest point is a sitting minister with 50 armed officers, then no Nigerian's land title is truly secure. The critical date is April 23, 2026. That is when this matter returns to Justice Mwazu's court. If Wike's legal team appears and offers a path to purge the contempt, either by complying with the original order or presenting a legally adequate explanation, the court may accept a resolution. If they do not appear, or if they challenge the court's authority directly, the escalation path leads to committal proceedings. Watch also for what happens on March 9th, the earlier adjourned date. Watch whether the presidency makes any public statement before then. Watch whether a second interference with the property occurs. And watch whether other FCT property owners with similar grievances begin filing their own contempt applications. Because if they do, this is no longer one case, it is a pattern with a name. The most dangerous outcome of this entire saga is not that a minister goes to prison. The most dangerous outcome is that the contempt is quietly purged, the media moves on, a settlement is reached in the shadows, and the message permanently lodged in the institutional memory of Nigerian governance is that court orders are negotiable for those with enough power. That is the outcome that would matter for the next decade of Nigerian democracy. Now, back to the question I set at the beginning. Why would a trained lawyer deliberately defy a court order that was already served on him? The answer is this. He calculated that the political cost of compliance, appearing to yield to a property owner he had already moved against, was higher than the legal cost of defiance. That is a calculation that only makes sense if you believe the courts ultimately cannot touch you. April 23rd will tell us whether that calculation was correct. We started with one question. What happens to the rule of law in Nigeria when the man who controls the capital city treats a court order like a suggestion? Here is the measured answer. We do not yet know, because the courts have not finished speaking. What we know is that the mechanism exists. Forms 48 and 49 have been served. The date is set. The institution is responding exactly as it should. Now we watch what happens when that institution is truly tested. If this analysis gave you clarity, share it with one Nigerian who needs to understand what is really happening. Like, subscribe, and I will see you in the next one. Naija Update 24/7. We never stop watching.